these companies want to keep this stuff out of court. They don't want the constitutionality of this to be tested in court because I argued that it's not constitutional. I think at the very least, it's an issue that's up in the air, whether this is legal or not. And so if you can keep this out of court, then it won't be held unconstitutional. You can keep selling this data. So these companies often have contracts in place, almost like non-disclosure agreements that say, don't mention our product in a public record, don't mention our product in court. You can use it to generate leads and sort of dig this evidence up through other means. That's a process referred to as parallel construction. And it's sort of a way of hiding surveillance techniques.
I'm Stephanie Pell, Senior Editor at Lawfare, and this is the Lawfare Podcast, December 4th, 2023. Is the Fourth Amendment doing any work anymore? In a forthcoming article entitled Government Purchases of Private Data, Matthew Tokson, a professor at the University of Utah S.J. Quinney College of Law, details how, in recent years, federal and state agencies have begun to purchase location information and other consumer data, as government attorneys have mostly concluded that purchasing data is a valid way to bypass Fourth Amendment restrictions. I sat down with Matthew to discuss this article, where he attempts to bring this constitutional evasion to light. We talked about the two main arguments offered for why the purchase of private data does not violate the Fourth Amendment, his responses to these arguments, and the recommendations he makes to courts, legislators, and government agencies to address the Fourth Amendment and privacy concerns surrounding government purchases of private data. It's the Lawfare Podcast, December 4th. Matthew Tokson on government purchases of private data. Matthew, can you start by telling us what prompted you to write this article?
Yeah, actually, it was an article that I read online about the Barnstable, Massachusetts Police Department, Barnstable being on Cape Cod, purchasing location data on people, purchasing a service where they could track people's location data via their cell phones. And, Barnstable, Mass, I associate it with the Cape Cod of my youth, this sort of small town, not a whole lot of crime there. And it just sort of struck me and shocked me a little bit that the Barnstable Police Department felt that they needed to closely track people's locations. And that's sort of when I'd heard earlier stories about the government purchasing, location data for various purposes. But that's when it sort of struck me that this had grown to a sort of crazy extent and was a little more ubiquitous than I thought. And that's basically when I decided to write the article.
Can you describe the kinds of data that law enforcement are purchasing?
For the most part, it's data collected by cell phone apps. There are other sources of information, but that's sort of the main one. And typically, we're talking about location data that apps might collect, oftentimes weather apps, games, could be dating apps, things like that. These apps collect this data for marketing purposes mostly, and they sell it to data brokers. Some data brokers have created software that can help law enforcement track people with this data. Now, there's other data as well that government agencies have purchased, often internet traffic data, like IP logs and things like that, where it's a little hard to know exactly what they can tell. But typically, if you have a list of IP addresses that people have visited, you can sort of tell whether they've been on the internet. So that could be very sensitive. And then there's other types, but those are sort of the big main categories that I'm aware of.
And you referenced the fact that data brokers are selling these data sets. Is that the primary kind of company that is selling these data sets, or are there other companies as well?
I think that's the primary kind of company, but typically when we're talking about the company that's selling to law enforcement, it's often a specialized subsidiary of a larger data broker, and they typically create sort of specialized software that can help track phones or other units within a location, or perhaps enter someone's name or other information, or enter a cell phone number and sort of reverse look them up. In other words, the tracking function of this software tends to be a lot greater and a lot more capable than what you'd purchase from a data broker if you were, an advertising company, which is usually just going to be sort of a big block, a huge Excel spreadsheet or other database of anonymized consumer information.
So as you were researching and writing this article, I think you came across cases and situations where law enforcement purchased location data, and we're now seeing how these data are actually being used in an investigation. Can you give us an example of that?
Sure. Yeah, my favorite example is it was a government agency purchases data around the border, and they're seeing cell phones, transit back and forth across the border in a very straight line. And they eventually figure out that this is an underground sort of smuggling tunnel. The tunnel begins in a house on the Mexico side, and it terminates in a Kentucky Fried Chicken on the United States side. This is a Kentucky Fried Chicken that went out of business, and they use this data to sort of figure out that the owner of this Kentucky Fried Chicken was involved in drug trafficking, but they don't want to sort of expose that they know this or that they're purchasing this data. So they contact local law enforcement. I believe this was in Arizona, and they say, "Look, there's this individual. His name's Ivan Lopez. You're going to want to pull him over. We suspect he has lots of drugs in his car." So the local police pull him over basically on a pretext. They said that there was an equipment violation, like a tail light was out or his license plate was obscured or something like that. They pull him over. They find the drugs that the government already knows are there, and they sort of prosecute him from there. So it's an example of the government using this data, which originally collected for immigration enforcement in this case, and giving it to another police agency, and also sort of hiding the fact that they've obtained these massive sort of databases of location data by purchasing them.
And I know we'll touch on this probably later in the conversation, but it seems to be one of the challenges of learning and regulating these practices are the fact that law enforcement uses of these data are often obscured downstream in investigations where they may provide leads.
That's right. I think largely at the direction of the data brokerage companies themselves, these companies want to keep this stuff out of court. They don't want the constitutionality of this to be tested in court because I argued that it's not constitutional. I think at the very least, it's an issue that's up in the air, whether this is legal or not. And so if you can keep this out of court, then it won't be held unconstitutional. You can keep selling this data. So these companies often have contracts in place, almost like non-disclosure agreements that say, don't mention our product in a public record, don't mention our product in court. You can use it to generate leads and sort of dig this evidence up through other means. That's a process referred to as parallel construction. And it's sort of a way of hiding surveillance techniques. We see that a lot when we're looking at government purchases of private data.
So who is allowed, so to speak, to purchase these data sets? You've talked about law enforcement purchases, but are they marketed and sold to other audiences as well?
When we're talking about the sort of tracking specialized software, those seem to be marketed exclusively to law enforcement. And there are companies that will sell these services to law enforcement, and they'll also help them throughout their investigation to, de-anonymize an anonymous phone number, for example. The marketing, at least, is very specialized towards law enforcement. And if you try to purchase these services, you're not going to be able to, I guess, unless you lied about who you are, perhaps. In terms of location data in general, sort of more raw data without the specialized tracking ability, that stuff is often sold from company to company, from a data broker to an advertising service to a marketer, marketing analysis, sometimes to credit card companies. But when we're talking about that data, as I said, typically we're talking about large anonymized databases. Now, it is possible to de-anonymize that information. Sometimes you can purchase information that's linked to names, but this is business-to-business sales. I have, purely out of academic interest, I've tried to purchase, useful location tracking information just to see if I could do it. And there's just not a consumer-facing sort of store you can go to. There's no stalking store where you can stalk whoever you like. This information is not available to the public. With sufficient expertise, if you start a corporation, if you have millions of dollars, you might be able to get this information and process it in a way that could be useful for tracking someone. but that's not really available to the general public in any meaningful way. It's hard to get if you're not a corporate entity, and the really useful stuff is almost impossible to get unless you're law enforcement.
And so the fact that the data is not generally available to the public, I think, sets up nicely the main argument you make in your article, which is that law enforcement's purchase of location data likely violates the Fourth Amendment. So first of all, I want to start with the question of if law enforcement wasn't purchasing location data, how would it normally be required to obtain it? Is there a particular case that provides some insight to that question?
Yeah, absolutely. In 2018, sort of the last major Fourth Amendment case is called Carpenter versus United States. And the Supreme Court decides in that case that the police can't obtain cell phone location data without a search warrant. What they were doing prior to Carpenter is there was a statute that sort of allowed you to get a court order, very easy to get. And you could get a court order, send it to Verizon or Sprint or whoever, and say, give us the location data for the past 6 months on 1-800 whatever phone number. And so police were doing that in a fairly often. It was a fairly common investigative tactic. The Supreme Court said, look, this data can be very revealing. There's a lot of it out there. It's very sensitive and private. And so we're going to require you to obtain a search warrant before getting it, even though it's held by the cell phone company and sort of is not your traditional private data. They extended the Fourth Amendment to that location information. So that was sort of the pre-Carpenter. Police were just sort of getting it directly through what's called a 2703D court order, which again was fairly easy to get with a lower standard than probable cause.
And for the Electronic Communication Privacy Act nerds out there, the 2703D order is part of that statute, I presume.
That's correct. It often referred to as the Stored Communications Act, like this particular portion of the ECPA, but it's all the ECPA. That's correct.
And the Carpenter case, as you noted, dealt with historical cell site location information, or often called CSLI. But with the type of data that you've been talking about, we're in many circumstances talking about much more precise location data from these apps. Is that a fair assessment?
That's right. CSLI is sort of location data that you obtain from the radio waves of a cell phone hitting various cell phone antennas, throughout the city or town that you live in. And depending on how many cell phone towers there are, it can be more precise or less precise. But the cell phone location data that is available for purchase is typically not CSLI. It could be, but it's typically not. It's typically app generated. And that's often more precise because it's usually GPS based. And so you can usually pinpoint people a little more accurately with that information than with CSLI. The flip side of that is it's not as universal as CSLI, perhaps, depending on the user, because CSLI is generated whenever a cell phone is on. But it is often much more precise and sort of can reveal even more about a person's life because it follows them so closely.
And as best you can tell, did the growth in law enforcement purchase of location data begin occurring after the Carpenter decision?
Yes, I find that very interesting, that a lot of major purchases of cell phone location data were made by government agencies, especially federal agencies, almost immediately after Carpenter in the summer of 2018, which is Carpenter was released in the early summer of 2018. And so, a month later, a few weeks later, some of the Department of Homeland Security and the Defense Intelligence Agency are making purchases of cell phone location data. Now, this is circumstantial evidence, but it seems reasonably likely that they were making these purchases in order to engage in the location tracking that had just been declared unlawful without a warrant by the Supreme Court. So I think that timing is very revealing, at least in some cases.
So as you've indicated, prior to Carpenter, for the most part, the government was using these 2703D orders, which have a lower standard than a probable cause standard that you find in a warrant to obtain CSLI. Then Carpenter happens, and then we see this growth in the purchase of location data. So, as you understand it, what are law enforcement's best arguments for why they can purchase what they would otherwise be generally required to get a warrant to obtain? And if I know you make several arguments in the article, so let's take them one at a time.
Sure. So I think the first, main argument that government attorneys have made is because this stuff is commercially available, it is unprotected by the Fourth Amendment. And the basis for that is the sort of general rule based on a case called Maryland versus Macon from a while back that the police officer can go into a store that's open to the public and purchase goods or what have you that any member of the public might purchase, and that's still good law. So I think they're trying to draw an analogy between purchasing something in a store and purchasing location data.
But that's not an argument that you find terribly convincing.
I don't, in large part because, as we talked about a little bit, I don't think this stuff is really available to the public in any meaningful way. Again, I haven't been able to purchase it. There's no store you can go to and purchase detailed location data on someone, certainly not in a way that's useful for tracking either. And so that, takes it out of that sort of realm of being publicly available in the first place. And I would also say that under cases like Kylo versus United States and some prior cases, the court has looked at types of surveillance that a member of the public can in theory undertake, and basically said, look, if this isn't in general public use, if this isn't something that happens more than very rarely, we're not going to hold that to sort of erode the Fourth Amendment protections for something, right? In Kylo, there was the police used an infrared camera to scan the outside of someone's house. Now, you or I could buy an infrared camera. It's unlike this location data. We could buy an infrared camera. We could likely scan the outside of someone's house from a public area without getting in trouble for it. Although I suppose maybe they'll sue us. That's sort of up in the air. But
not very neighborly.
Yeah, it wouldn't be. Yeah, they would probably give us a dirty look and not understand what we were doing with this large camera. But the court said, yeah, sure, a member of the public could do that. A contractor or someone could do that. That's typically who uses these cameras. But it's not in general public use. This is not something that is widely used enough to erode reasonable expectations of privacy. And I think there's an analogy to that, to this situation where, even if a few sophisticated actors might be able to purchase this data, that's not enough to say that the Fourth Amendment doesn't protect it. And it's certainly nothing like a situation where you walk into a store and purchase something, and so the police officer should be able to do the same thing. I think this is, quite different from that. Accordingly, I think the Fourth Amendment still protects this data, which is, as the Supreme Court has said to CSLI, something very similar, is private, is generally protected by the Fourth Amendment.
And has there been any court that has addressed this question of whether law enforcement's purchase of private data violates the Fourth Amendment rights under Carpenter?
Yeah, there has been one court that looked at a service that was working closely with law enforcement. And so law enforcement were basically purchasing a tracking service from them. They would ping someone's cell phone and get sort of a CSLI-like response as to where a person was at any given moment. The only reason this made it to court was there was a criminal prosecution that sort of obliquely mentioned it. And so the party took offense to that, sued for a constitutional violation under Section 1983. And so this got evaluated by the court. And the court basically said, we think that this company is so closely working with the government to track these people that it's essentially a state actor. So I think there are some lessons there for a lot of the tracking services that I study, which also work closely with the government to help them track people, often work to help them de-anonymize people once they have a target in mind. It may not be exactly the same because the way that a company tracks someone may vary. This may have been more involved. Some other companies may have less direct involvement. But according to the one case sort of on this issue, at least at the time that I wrote the piece, which was fairly recently, that court said, look, this is unconstitutional. This is basically a private company doing a government function, engaging in state action and violating people's privacy under the Fourth Amendment.
And was that a district court opinion?
Yes, that was just a district court opinion. So it still remains to be seen what the federal appeals courts will say about it, and certainly the Supreme Court hasn't addressed this particular issue at all.
So you make a second, or you identify a second argument that government attorneys generally make about why they don't need to obtain a warrant to get this kind of location, purchase this kind of location data.
Yeah, that's right. They also argue, in addition to the fact that it's purchased, that because cell phone users typically, hit sort of permit on their apps to allow the app to collect data, that they may have no reasonable expectation of privacy in the data, even under Carpenter, right? In Carpenter, with CSLI, you sort of have no choice but to reveal it. Here, they're saying, they sort of give permission for the apps to collect it.
Can you unpack that a little bit? I mean, basically, is the argument that somehow every time I give an app permission to collect data, that I am simultaneously giving it permission to share data in a way that then diminishes my Fourth Amendment rights?
Yeah, that is the argument, and I push back on that in my piece for a couple reasons. One is I think if we're talking about consent to like a Fourth Amendment search, I don't think merely giving weather.com's weather app permission to view your location is anything like giving consent to the government to collect that information downstream and use it against you. It's also the case that I don't think 99% of people, when they're clicking yes on the app, have a sense of where that data might go, even, excluding law enforcement. If we're just talking about data brokers and subsequent sales to third-party marketers, that stuff's not disclosed in the initial permission screen. The permission request is typically really minimal, doesn't really say almost anything about how the information will be used, especially when we're talking about marketing. And so I don't think it's a meaningful waiver of any constitutional right for those reasons. It's also, I think, the case that usually it's not much of a choice. It's a choice, but it's not really a choice. You can deny your app's permission to collect various kinds of data, but oftentimes they won't work, or they won't work properly. They'll be greatly diminished. And so for these and even more reasons, I think giving an app permission to collect your data is not sufficient to sort of waive your Fourth Amendment right in that data, if it's otherwise private, if it's otherwise sensitive under Carpenter.
We have not seen that particular issue in this context addressed by a court yet.
Yeah, I think that's right. I mean, you see it a little bit in the geofence warrant context, a completely different sort of issue involving, location data collected by Google and obtained usually via a warranted search, although geofence warrants are sort of their own special thing where the police get a warrant for all the cell phones in a location. So I think there have been a case or two that talk a little bit about, is that, do people give their permission for that? But even that's a little bit different because Google is a little more detailed in its disclosures. So, some lower courts especially have touched a little bit on these issues, but not in a way that I think is particularly useful for analyzing it in the government purchases context.
Now, in addressing some of the privacy implications of law enforcement's ability to purchase private data, you talk about the interoperability of private and law enforcement surveillance. Can you explain what you mean by that?
Yeah, this is a concept I'm borrowing from Karen Levy, who has this great book about private surveillance, or rather public surveillance of long-haul truckers and how that's been used by their employers sort of against them. They sort of piggyback on the government's tracking of the truckers for safety, which is done for safety reasons. And she talks about the interoperability of government surveillance and private surveillance, right? Once the government has, sensors in place to sort of make sure the long haul truckers aren't driving too much or driving too fast or et cetera, the private entities can use that to track them as well. This is, I believe her book's called Data Driven, and it's really like this concept from that and like Karen Levy's work. But so I think what we're seeing is sort of the reverse of that here, which is we have sort of extensive private data collection, right? private, not so much private surveillance, but just extensive collection of consumer data as they use their cell phones, as they surf the internet, as they move about the world. That data is collected almost exclusively for marketing purposes because it has some monetary value because you can sell it to advertisers and marketers. But because that data collection is so unregulated and so ubiquitous, it creates an opportunity for law enforcement. And the government has now identified that opportunity. That's why we see, I think, an increase in government purchases in recent years. And so instead of creeping from sort of government surveillance to private surveillance, we're creeping from private data collection to government surveillance. And that's the interoperability. The same data that the Angry Birds app collects on you might be useful to law enforcement, and they increasingly are able to obtain it.
So I want to talk about some of the solutions to these issues that you propose in your article. And I want to start with how you would advise courts to address the problem. And I would just focus back on a comment that you made earlier in this discussion. And that is that oftentimes it is difficult for courts to even rule on these issues because the purchase of the data is obscured in the investigation. So it really never fully comes to light. And it's often difficult then for defense attorneys to raise these issues.
Yeah, that's right. Often in the Fourth Amendment context, there are judicial solutions. And I've typically been an advocate of court-based solutions for a lot of Fourth Amendment questions. Here, it might be a little different because it's so rare for government purchases to come before a court because the data companies selling them are so reluctant to allow them to come into court, to even be mentioned in court. So they're being used in the background, but they're tough to challenge. And so if we're talking about a sort of judicial solution, it's often there's going to be a preliminary step, which is doing like a FOIA request or engaging in FOIA litigation or other transparency litigation to even get the information about what the government is doing. If you can, and there's some great people who write about that, Rebecca Wexler, Hannah Block-Weba, they've written some articles that I find useful about sort of transparency litigation in the law enforcement area. But so you'd almost have to prevail in like a FOIA litigation, or at least with a FOIA request, to figure out what, a given government agency or police department are doing. Once you have that information, maybe there could be a lawsuit and it would get into court. But short of that, it might be difficult to weigh these things in court. And so in this context, there may need to be a statutory solution. And there are members of Congress, Ron Wyden in particular, who's often a leader in privacy issues, who have been working on legislation to prevent sales of consumer app data to law enforcement. Senator Wyden proposed, I believe it's called the Fourth Amendment is Not for Sale Act. It has not yet passed, but is still being revised and potentially reproposed. And there are other potential avenues of statutory law that might work that way. But there's a lot of things you could do either to directly prohibit this stuff, or we could also obtain the sort of long lost comprehensive privacy law at the federal level that we haven't really had. We have the ECPA, which was passed in the 80s and has been amended pretty minimally since, that is not really an effective comprehensive data privacy law for consumers. So we could have a more consumer-friendly, privacy law at the federal level, something that's a little bit more like Europe's GDPR, where consumers have more rights and more protections, where companies have to get explicit consumer permission for downstream sales. And that requirement in particular is relevant here because if the way these markets flourish is once, an app collects your data, they can sort of do what they want with it downstream, even without your permission. They don't really get your permission for the downstream stuff. They collect it. They might get your permission for that, but then they sell it without your knowledge and certainly without your permission. In the European context, under the GDPR, you typically would need consumer permission for every subsequent use of the data. They use it initially for whatever purpose. They're going to sell it to a data broker. If they're going to sell it to law enforcement, they would need to get your permission. And I think that kind of requirement would also likely prevent government purchases of sensitive private data, because I don't know who or why anyone would give their permission to sell their data to law enforcement, right? Maybe if you offered them a ton of money, but I don't think they're going to give it up for free, which is basically what they're doing now under current U.S. law. So there are a variety of statutory solutions that might prevent government purchases of sensitive data.
And what about government agencies? Are there things that you think they should be doing now, notwithstanding the fact that the courts aren't currently preventing the sale and purchase of this data by law enforcement, and the fact that as we are recording this podcast, Congress has not taken any significant measures to limit its sale and purchase?
Yeah, agencies may play a really useful role here. The FTC has looked into more vigorous consumer data enforcement. They are typically the agency that has done the most previously, typically through case-by-case litigation and adjudication. But they have looked at some more comprehensive regulation. Whether or not that will actually happen, I'm not sure. But they certainly have the capability. I think they have the statutory authority to promulgate rules that might get us a large part of the way towards, preventing downstream uses of sensitive consumer data, even directly preventing government purchases of private data. I think the FTC could certainly do that. And they have at least looked into expanding their protections for consumer data. I don't know if they've looked specifically at government purchases, but these issues are on their radar. There was recently a study of government purchases, throughout the government by intelligence agencies that sort of touched on the massive scope of this practice. And so I think there's a little bit more awareness out there. It remains to be seen whether the FTC or I suppose some other agency might come to address it. But I think they have the capability and to some extent the interest in addressing these purchases.
Is there anything else that you would like to share with our listeners?
I would just say to keep paying attention to this issue. I think there will be some opportunities to get legislation on the agenda that may prevent government purchases of sensitive data, and any contact with congresspeople, any sort of social media activity about this issue can help. Eventually, it may also reach the courts, which would be really exciting to me. It's a ongoing issue. I think it's an exciting one. Stay tuned. We'll see what the future brings.
Fair to say that for Fourth Amendment nerds, it's a really hot issue.
I think so. Certainly for Fourth Amendment nerd, I'm very excited about it and will continue to be even after the paper is out and finished.
Well, we'll have to leave it there today. Thanks so much for joining me.
Thank you. This was a pleasure.
The Lawfare podcast is produced in cooperation with the Brookings Institution. You can get ad-free versions of this and other Lawfare podcasts by becoming a Lawfare material supporter through our website, lawfaremedia.org/support. You'll also get access to special events and other content available only to our supporters. Please rate and review us wherever you get your podcasts. Look out for our other podcasts, including Rational Security, Chatter, Allies, and The Aftermath, our latest Lawfare Presents podcast series on the government's response to January 6th. Check out our written work at lawfaremedia.org. The podcast is edited by Jen Patja Howell, and your audio engineer this episode was Noam Osband of Goat Rodeo. Our music is performed by Sophia Yan. As always, thank you for listening.